The legal concept of pardon is being bandied about again as the time approaches for Donald Trump to be inaugurated again. There is much talk of pardoning the convicted participants of the January 6, 2021 attack on the U.S. Capitol building. The legal commentators on social and regular media often fail to discuss that accepting a pardon has its costs as well as the obvious benefit. In particular, when one accepts a pardon, it does not relieve that person of all of the consequences of having been convicted. To be clear, federal case law sets forth what a presidential pardon is. Quote, a presidential pardon relieves the offender of all punishments, penalties, and disabilities that directly flow from the conviction. Yet, it does not prohibit all consequences of a pardoned conviction, but rather precludes future punishment for the conviction, end of quote. The same federal court opinion from which the above quote is taken also states, quote, rather, contrary to popular belief, modern case law holds that a pardon in no way reverses the legal conclusion of the courts. It does not blot out guilt or expunge a judgment of conviction, end of quote. Indeed, the U.S. Supreme Court has stated, quote, a pardon carries an imputation of guilt. Acceptance of the pardon is a condition of the pardon, end of quote. More than 100 of the persons convicted of attacking the Capitol also hold a record of other felonies. A pardon does not wipe away the record of the felony or felonies associated with the attack on the Capitol. So, sentencing for conviction of any future felony can count the pardon crime as a past felony. Accordingly, keep this in mind when commentators discuss presidential pardons. The object of the pardon admits committing the crime by simply accepting the pardon. They don't get off free and clear